Next matter to come before the court this morning is Stiner versus Amazon.com, Inc. Before we move on, does anybody have any issues about being visually and audibly recorded? Nothing being posted, filed?
I'm sorry, I'm having a hard time hearing.
There was a concern about being visually and audibly recorded and posted online. Does that concern still exist?
We have no concern, Your Honor.
Okay.
We have
All right, great. Then both parties will have 15 minutes in which to present their case this morning. If you're the appellant and you wish to remain, you take up to 5 minutes for rebuttal. I am keeping track of the clock and will keep you apprised of the passage of time. We are being visually and audibly recorded to be posted online, so please try to remain behind the front podium here as much as possible. We have read your briefs and we're ready to proceed with you. You need to move up to this front
Oh,
podium.
I'm sorry. I'm sorry, did you say that you automatically reserve 5 minutes for rebuttal? Or?
No, however much time you need, up to 5 minutes.
Thank you.
How much would you like to retain?
4 minutes.
Okay, thank you. I'll keep you apprised.
Ready? May it please the court. My name is Ed Juris, and I represent appellant Dennis Stiner. I'd like to reserve 4 minutes for rebuttal, which will be argued by my co-counsel, Brian Balzer. This case arises out of the tragic and unnecessary death of 18-year-old Logan Stiner, who died after ingesting a deadly pure caffeine powder marketed and purchased as a dietary supplement on Amazon.com. In finding as a matter of summary judgment that appellee Amazon could not be held liable under Ohio's products liability law, the trial court committed multiple reversible errors, which stem from two fundamental errors. First, in finding that Amazon was neither a supplier nor an offerer of the deadly powder, the court simply accepted without question Amazon's claim that it was nothing more than a neutral party for sales by a neutral platform for sales by a third party. The court ignored myriad facts and expert testimony demonstrating that Amazon, in fact, was an indispensable party in the sale of the deadly powder, that it promoted the powder as a dietary supplement and a product you may like, and that it clearly participated in placing the powder in the stream of commerce. In its second fundamental error, the trial court failed to consider public policy considerations, particularly the incentivizing of safety, as factors in determining Amazon's status as a supplier or offerer of the powder. Amazon was not, as it claims, a neutral and indifferent party in the sale of the powder that killed Logan Stiner. Amazon, in fact, entered into a contract with its third-party partner, Tincoris, whereby it agreed to market and promote the deadly powder. Because it received a percentage of the sales, Amazon had an incentive to market and promote the powder. The more powder that was sold, the more money Amazon would make. When Kelsey Kidd, Logan's high school friend, went on Amazon.com, she was simply and innocently looking for a pre-workout. She had never heard of pure caffeine powder or the product she ultimately purchased. It was Amazon, pursuant to its agreement with Tincoris, that promoted the deadly powder to Kelsey and told her it was a product she may like. Amazon concedes that the section where Kelsey saw the deadly powder certainly could be considered merchandising. Amazon further concedes that its goal in promoting products is to introduce the customer to a product they might otherwise not know about. In other words, Amazon pointed Kelsey Kidd to the deadly powder, a product she had never heard of, and said, "This is a product you may like." And it concedes that these were the acts of Amazon, not the acts of Tincoris. These are not the actions of a neutral party. In its business solution agreement with Tincoris, Amazon agreed, "We will list your product and conduct merchandising and promote your products as determined by us." Critically, Amazon has now changed that business solutions agreement. It now reads, "We will enable you to list your products and conduct merchandising and promote products as permitted by us." So in other words, under the facts of this case, Amazon said, "We'll promote the product, we'll sell it for you," and now they've changed that to say, "You list it."
Counsel, is any change by Amazon appropriate evidence for us to consider?
Well, it's indicative, I understand your point, Your Honor, but it's indicative of, I'm pointing out the fact that they did have the agreement to promote it, so that's really the key point for this case. Amazon, moreover, structured its website to encourage Kelsey Kidd to believe she was buying the product from Amazon and that it was safe. Amazon considered Kelsey to be an Amazon customer. It completed the whole transaction on Amazon.com. It accepted an Amazon gift card and payment, thereby giving the impression that the powder was an Amazon product. It provided an A to Z guarantee. It listed itself as the merchant of record on the credit card receipt, and it walled off all contact between Tancoris and Kelsey. These facts demonstrate that Amazon, in addition to promoting the powder, facilitated the sale by encouraging Kelsey to believe that she was dealing with Amazon and that she was buying a safe product. In Friedland versus Amoroso, the Supreme Court of Florida held that a hotel could be held strictly liable as a lessor of a sailboat because it led guests to believe that the hotel was renting the sailboat, and the guests could expect that the sailboat therefore would be safe. At the summary judgment stage, the trial court was obligated not merely to consider this evidence, but to construe all facts and resolve all doubts in favor of the non-movement Dennis Stiner. The court utterly failed to do this. Echoing the language of the Inman versus Technicolor USA, the only case it cites on point, the court says the plaintiffs failed to demonstrate that the activities of Amazon amounted to anything more than providing an online forum for the seller. Yet the Inman case was decided at the motion to dismiss stage on the bare bones pleadings of the plaintiff. And the court said, we're going to give them leave to amend to add facts and allegations and evidence that eBay, the defendant in that case, did more than what is stated in the initial pleadings. That is exactly what appellant Dennis Stiner did here. He showed how Amazon promoted the powder, introduced it to Kelsey Kidd, and told Kelsey it was a safe product, or a product she may like, I should say. He showed how Amazon encouraged Kelsey to believe she was buying the product from Amazon. He presented expert testimony of Professor Robert Hamilton, an expert on the Amazon business model, who stated that Amazon did far more than provide a neutral forum, and it clearly participated in placing the powder in the stream of commerce. Instead of construing these facts and resolving all doubts in favor of the non-movement, the court did the opposite. It ignored Steiner's facts and relied on those presented by Amazon. For example, the court notes that certain receipts listed bulk source as the seller. It ignores the fact that the credit card receipt listed Amazon as the merchant of record. The court cites the testimony of a pharmaceutical expert who was not qualified on this particular point on what constitutes placing a product in the stream of commerce, but completely ignores a business expert, Professor Hamilton, who said that Amazon, through its business model, did participate in placing this in the stream of commerce. The court dismisses Kelsey's Kidd testimony that she thought she was dealing with Amazon, and instead cites comments that Kelsey made on cross-examination that were favorable to Amazon. So you have the court doing the reverse of what it was required to do at the summary judgment stage. It's relying on the facts of Amazon, it's construing those facts in favor of Amazon, it's resolving doubts in favor of Amazon, and it's ignoring its obligation to do the exact same thing in favor of the non-movement. That is plain and reversible error. In its second fundamental error, the trial court utterly failed to consider public policy considerations as factors in determining Amazon's supplier status. In Welch versus O&K Trojan, to determine whether the defendant was a supplier, the Court of Appeals for Hamilton County looked at the public policies underlying the product liability laws and asked, did the defendant facilitate placing the product that caused injury in the stream of commerce, and would holding that defendant liable advance the policies underlying Ohio's product liability laws? Ironically, in the Inman case, the only case the trial court relied on, the court said exactly the same thing. It said the plaintiff failed because he did not, in his initial complaint, show how holding eBay, the defendant in that case, liable, would incentivize safety. So that's the factor you need to look at. Are you going to advance, is the company facilitating the sale, and would holding it liable advance the policies underlying product liability laws? Here, in granting summary judgment, the trial court did not even consider the public policies underlying the product liability laws, particularly the incentivizing of safety. Amazon clearly was in the best position to keep this powder off the market. Tancoris was a small one-man operation in Arizona. It had no incentive and no capacity to protect the public. Amazon, by contrast, is one of the wealthiest companies in the world. Its own expert touted the screening process that it had for products. Holding Amazon liable would plainly incentivize safety by encouraging it, under the egregious circumstances of this case, to remove a deadly ingestible product from its website rather than to promote that product as something you may like. In Welch, the Court of Appeals for Hamilton County gave a roadmap for determining supplier status under Ohio law. It asked, did the defendant facilitate the sale of the product that caused injury, and would holding that defendant liable advance the policies underlying Ohio's product liability laws? Here, the trial court again utterly failed to undertake that analysis. It simply accepted Amazon's claim that it was merely a neutral forum. It put on blinders and it refused to consider any further evidence. And you see, Amazon, even in its brief, says, we're nothing more than the classified ads or a credit card company. In fact, they signed an agreement with Tinkoris saying, we'll promote your product. They lost their neutrality at that point. They're no longer Switzerland. They're a promoter of the product, and that's where their liability rests. The court, moreover, never considered whether holding Amazon liable would incentivize safety, despite clear evidence that it would. The case for incentivizing safety is particularly compelling, where a party is warned of the dangers of a product it promotes and has the capacity to remove rather than promote the product. The court did not consider the public policy considerations underlying Ohio's product liability laws in determining Amazon's supplier status. In short, the trial court never conducted the required two-step analysis, and that is error. Reasonable minds plainly conclude that Amazon participated in placing this powder in the stream of commerce. And if reasonable minds could find that in favor of the non-movement, summary judgment must be denied. In refusing to conduct the required analysis, the trial court failed in its obligation to construe facts and resolve doubts in favor of the non-movement. It failed to conduct the two-step Welch analysis, and it failed to recognize that genuine issues of material fact precluded summary judgment in this case. As in the Polito and Arguto case cited in our brief, the trial court should have conducted a trial to resolve these facts, to determine Amazon's true role, and consider whether holding Amazon liable would incentivize safety. Based on its failure to do either of those things at the summary judgment stage, the trial court's decision should be reversed.
4 minutes remain.
Okay. And I would just like to point to the analogy that Professor Hamilton made. He said if you went into a CVS and said, I'm looking for a headache medication, and the clerk says, I've got just the thing for you, takes you over there and gives you a bottle that has cyanide in it. That is basically what Amazon did here. They pointed Kelsey Kidd to, she was looking for a dietary supplement, just a pre-workout, something to boost her energy level. And they say, here's a product you may like, and they do it pursuant to an agreement with Tinkoris to promote that product. So she trusts them and purchases a product she'd never heard of before, and as a result of that, Logan Stiner is dead. Now, if someone walks into a CVS, as Professor Hamilton says, that goes through the same process and is directed to a deadly product, clearly CVS would have promoted that product, clearly CVS would be liable. Same analysis applies here. In closing, I'd just like to make 2 quick points on the Communications Decency Act, which they say absolves them of any responsibility. First, the CDA does not apply if Amazon was a supplier or an offerer of the powder. In that case, Amazon's own actions would be at issue, and the case law indicates that the CDA does not shield a party from liability for its own actions. Moreover, Amazon, through its 30B5 witness, Damon Jones, admitted that its promotional actions in this case were the acts of Amazon, not the acts of Tinkoris. So we're clearly outside the CDA. Moreover, the Daniel case, which is cited in our brief, provides a compelling rebuke to the overbroad reading of the CDA in the cases that Amazon advances. The court notes that there is a presumption against federal preemption of state laws, and that state laws are not to be superseded unless that is the clear and manifest purpose of Congress. That expression of a clear and manifest purpose is completely absent here. In addition to being unjustified, Amazon's overbroad reading of the CDA would result in the kind of blanket immunity the courts have warned against. It further would allow Amazon to claim immunity even if it would allow the deadly powder to be listed for sale today, and it recommended that powder as a product you may like. It could still fall back and say, we didn't create the listing, so we're immune. That clearly is not the law. Am I?
You only have a minute and 30 seconds total remaining, so.
Oh, I'm sorry, I didn't, we'll hold the remainder for rebuttal. I'm sorry.
I'd like to begin with the same place that Mr. Turst did. That is that I think we all understand that this case arises out of a tragic accident. And Mr. Steiner's family has obviously suffered a terrible loss. The question for us is not, should they be able to seek compensation? Because of course they should, and they can, and they have. From this kid who provided the powder to Mr. Steiner, from Tencoris, the company that sold it to her. The legal question before you today, rather, is the narrow question of whether Amazon is subject to liability for having acted as a marketplace and facilitated the sale by Tencoris of this product to Ms. Kidd. And the answer to that question is no, as the trial court correctly held, for two independent reasons. The first is that Amazon's actions in providing a marketplace do not make it a supplier under the Ohio Product Liability Law or an offer for sale under the Pure Food and Drug Law. And the second is that regardless of the resolution of that state law question, the Federal Communications Decency Act immunizes Amazon for its activities here, which involve the operation of an interactive computer service. So starting with the product liability issue, supplier is a defined term in the statute under 2307.71.15. It's a person who, there's a long list of verbs, sells, distributes, leases, prepares, blends, packages, labels, or otherwise participates in the placing of a product in the stream of commerce. And I think it's common ground here that Amazon did not do any of the verbs: selling, distributing, leasing, preparing, blending, packaging. Tencoris and the companies from which it purchased the ingredients of the powder did all those things. So the debate here is whether Amazon's activities constitute otherwise participates in the placing of a product in the stream of commerce. And the answer to that is no, and there are a couple of ways to look at it. One is that if you read that language, if you give it the broadest possible interpretation that the literal meaning of the terms would support, you would sweep in a lot of people with tangential involvement in a transaction. And that is not the way that the courts have read it. The courts have looked at the fact that you have an enumerated list of verbs, and then you have this catch-all clause, and you have to read them in conjunction. And what do all the verbs have in common? What they have in common is that they're all selling, distributing, leasing, preparing, blending. Those are all people who touch the product, who have possession of it, they have control over it, they have some relationship with the manufacturer. And the courts have been reluctant to extend it to companies that don't do that. So in Long, for example, it involved a financial lease. And the financier clearly participates in the delivery. They are a necessary participant. The transaction is not going to take place without them. But the reason that the court didn't deem them to be a supplier in Long was that they, quote, have no control over its manufacturer and it is not involved in the selection of the product or in any way makes a representation.
Well, there's an important point you just made, the selection of the product. In this case, she did not type in her search caffeine powder. Wasn't it Amazon's search engine or algorithm that directed her to this particular product?
So her testimony on this is at page 56 of her deposition. She put in the search term pre-workout, and then she said, quote, what happened was I clicked on a product, and you know where it says like similar product or products that you may
Except for
like.
who selected that product that gave her the choice to click on the caffeine powder product? Wasn't that Amazon?
Well, no, I mean, Amazon displays a list of products, and she clicked on one, and then it displayed some more, and she clicked on that.
But to get to the listing, isn't it Amazon's search engine, Amazon's algorithms that produces the list, supplies the list for her to choose from?
That's right, and in that respect, it's no different than if Tencoris had decided, rather than sell through the Amazon website, we're just going to have our own website. And they have their own website, so how do they get people to come to their website? They buy an ad from Google. And the result is that when you type in search terms into Google, you get a link to the Tencoris website. And that's a very common practice for businesses. But there's no court, of which I'm aware, that has suggested that that's a Google ad, makes Google a supplier. And in the old-fashioned
So
brick and
doing
mortar.
that does not mean they are otherwise participating in placing the item in the stream of commerce by searching for this particular Tencoris product and making it available to Kelsey.
I mean, they are, the part of the transaction that you have described is essentially displaying an advertisement. It's what Google does, it's what the classified ads do in the newspaper. And somebody has a product that they want to sell, and the newspaper decides which category of ads they're going to put it in, and they put it there. And the reason that they put it there is to encourage people to buy it, in the hopes that people will be flipping through the paper and see this ad and decide that that's something that they want to buy. That's the whole point of.
Well, putting an ad there anywhere is different than you might also like, which is, I guess, I think perhaps, I don't even know how long Amazon's been around. It's been a long time, but, when Amazon says you may also like, or other products you may like, or this product's available from other sellers at a lower price, or based upon your search history, you may like these products, based upon, I assume, the algorithms that they use. Hasn't it gone beyond the neutrality that you're arguing that it is?
Well, no, Your Honor, and the question under the statute is not whether you're neutral, it's whether you're participating in the placing of the product in the stream of commerce.
Hasn't it now stepped to participation?
Well,
Let me word it that way.
No, because all it's doing, again, is sort of promoting the product in much the same way that an auctioneer stands up there and says, this is a great car, low mileage, you want to buy this car, I'm going to start bidding at $1,000. Like he's promoting the product, trying to get people to buy the product. But the cases are uniform, that an auctioneer is not a supplier under the statute. And I think it's important to keep in mind in terms of what exactly the promotional activity was here. The claim is not, the plaintiff's claim is not that Amazon gave bad advice. This is not Amazon was providing medical or dietary advice and was negligent because the advice was bad. The claim is that Amazon sold this product or should be treated as a supplier of the product. And merely advertising a product, as the newspaper does, as an auctioneer does, doesn't make you a supplier. The analogy was made earlier to, if you go into CVS and you ask for a particular product and the clerk there directs you to something, well, sure you can sue CVS there because CVS is selling you the product. This case is more analogous to you go into the mall and you ask the person at the information desk, where can I buy a product for a headache? And they say, well, there's a CVS in this mall. Go to there. The mall is providing space for the store to operate. It might be directing people to the store, as in that example. But you can't sue the mall as a supplier of the goods that you purchase at the store that's within the mall, any more than you could sue a flea market for something that you buy from a person who's at a flea market, any more than you can sue UPS or FedEx or the Postal Service, which actually brings the product to your door and then handles it and then gives it to you, and whether you buy it through Amazon or directly from a third-party website. So the cases are uniform across the states with respect to all of those kinds of entities, and they're uniform with respect to Amazon. As we noted in the brief, this has come up in a number of jurisdictions. The Ohio product liability law is broadly worded, but it is not uniquely broad. Other states either use Section 402A of the Second Restatement, which is quite broad, or they have their own statutes that have similar language extending to people otherwise involved in a transaction.
It just occurs to me that the difference between CVS then, from what you're saying, and what they're saying, the difference between CVS and Amazon is that CVS would have purchased all those items to put on their shelves so that they can sell them. Where Amazon doesn't buy any of the stuff that it puts on its website. It's all stuff that's sold third party.
That's exactly right. Amazon doesn't have, never has title to the goods. In this case, it never touched the good. And that's important because it goes to the policy considerations that have been discussed. Amazon has more than 1 million third-party sellers. It has millions of customers. People use it every day. Small businesses are able to sell things through it, and people are able to buy useful goods. That's a socially valuable activity, but Amazon simply can't be the insurer of every product that is sold by one of those third parties, as plaintiffs would call it, because they don't see or necessarily even touch the product. They have no contractual relationship with the manufacturers of those products that would allow them to have some control over how it's designed or how it's produced. And they certainly do care about the customers. I think it's noteworthy here that Amazon took down caffeine powder several years before the FDA prohibited its sale. As soon as the FDA issued guidance about potential dangers of the product, Amazon suspended third parties from selling it. But I think it's useful to keep in mind that Amazon is concerned about safety, but it's quite another thing to say that they should be in a position of insuring millions of products that they never see or touch. There's been some discussion of the potential facts that are in dispute. There's really, the ultimate question here is a legal one, which is this category of business a supplier under the statute? That's the way the court analyzed it in Long with the financiers. It's the way they analyzed it in Welch with consignees. Those are questions of law. There's no dispute about the relevant contractual relationships, about who had possession of the product, who had title to the product, who sold it.
Was there an issue of fact just between the two expert opinions as to what constitutes placing a product in the stream of commerce?
Well, so Mr. Hamilton, or Professor Hamilton, offered an opinion that's, I would encourage you to look at his declaration. That's Exhibit U to the plaintiff's motion for summary judgment, and it simply states, it is my opinion that Amazon promoted, offered for sale, and sold the product. Well, that's the statutory language. That's a legal conclusion. And you can't defeat summary judgment simply by getting an expert to say, here's my view of that the legal standard is satisfied. As to the actual underlying facts, there really isn't any dispute. If I could, I'd like briefly to address the Communications Decency Act, which is an alternative ground. You can affirm the judgment on either basis. And the key language is that a provider of an interactive computer service cannot be treated as the publisher or speaker of any information provided by another. And there's a lot of case law on this, and one of the things that is clear in the cases is that what matters for application of the CDA is what the facts are, not the label that the plaintiff chooses to attach to their claim. You have to look at the facts and ask, is the defendant, the service provider, being held liable for having allowed somebody else to speak? Are they being treated as the publisher of this information? And whatever Amazon said, products you may like, any of that, the only basis for the claim is that the information that was displayed was hard rhino pure caffeine powder at a price, and here's how you can buy it. And all of that information came from Tencorus. Amazon did not create it. Amazon had no involvement in creating it. So the information was the offer for sale of, here's a description of the good, here's its name, here's its price, you can buy it. That was all information provided to Amazon by Tencorus. And what the plaintiff is seeking to do is to hold Amazon liable for publishing that information to Ms. Kidd and allowing her to make the purchase. This is quite unlike the arms list case, which was a case set up to facilitate the illegal sale of firearms. The court in that case said that the relevant content was, quote, content created by an arms list, and that the operational design features of the website were set up to allow people to circumvent federal firearms laws. This, of course, involved a product that was legal to sell, legal to buy, and Amazon had no role in creating the information that was created by 10Course and displayed in history. Thank you, Your Honor.
Thank you. Thank you. You have just under 2 minutes remaining.
Please the court, my name is Brian Balzer, and I'm one of the attorneys representing the Stiner family. I would like to respond to Judge Callahan's question regarding why the BSA would make a difference in this case when it was changed. The reason it's a difference is because the cases that Amazon cites, saying it's uniform that Amazon is not a supplier, dealt with this change in the BSA. And to go to the BSA and determine exactly what those words mean to the BSA, we have to go no further than Amazon's 30B5 testimony from Damon Jones. I asked him, could you explain the word promote means in the paragraph as applied to the chorus in the agreement Amazon had with the chorus? Amazon's response, it is essentially saying we may choose to promote or merchandise your product at our discretion, or we may not. Further, he goes on to say it's the goal is to make customers aware of products that may be interested in purchasing they don't know about. And he says it's Amazon's action, it's not 10Course's action. She never knew about this product. All she wanted was a pre-workout. And also, I point the court, I don't have time to talk about it, to Rachel Greer in terms of product safety and the knowledge that Amazon had, and also in terms of the customer reviews and the knowledge that Amazon had. It's the same information that the FDA determined this was an adulterated dietary supplement, should be banned. The FDA sent an email to Amazon telling them, hey, we've got this issue, this issue, this issue, please stop marketing it. That's when they took it off the market. Not after Logan died, after the FDA sent them a letter is when they took it off, because they were marketing it. Back to, in terms of the reason they were entitled to a referral fee on this, is because they promoted, according to Mr. Jones in the 30B5, they promoted the merchandise, they promoted the caffeine powder, and he says, as determined by us. So they had a choice to make. She walks into their online store and said, I want a pre-workout. Same as walking in like a GNC. The algorithm is the sales associate, okay? The algorithm, which is Amazon's algorithm, the A9, and I point that in our brief, also all the experts have that information. Their algorithm, their information, their decision was that this was a product that Kelsey Kidd would purchase. And that was the goal, was to have to purchase. At the same time, they had knowledge that people could die from this. And the analysis
The only
of this...
product that came up on her search word was it a choice she had to make amongst multiple products?
Well, in terms of, it's just like going into the G, yes it is, Your Honor, it's just like going into the GNC store and say, hey, I'm looking for a pre-workout, and they said, oh, go to aisle 3, we have A, B, and C, and then you make that choice. I mean, the checkout, everything's the same in terms of it, and Professor Hamilton from Temple Fox Business School explains that in detail. The court ignored that. The court didn't even look at that. The court didn't take the analysis or the questions that you asked. It ignored these facts. They list the part of the business agreement that talks about the product. They don't even inquire about the part that talks about Amazon's action. This case is about Amazon's actions. Amazon's decision, just like they have the right to do, to make the decision whether they're going to promote it or not. They used Amazon's information that they had from Kelsey Kidd. 10Course did they have that information. That was Amazon's decision. Look closely at Damon Jones' two testimonies, and it's clear what they did. Amazon's actions, not 10Course.
And we will take this case under advisement.
Thank you for your time.
Thank you. Again, the court will take a matter of advisement, issue a written decision, which will be posted to our website and mailed to both sides as well. Thank you all for presentations today.